Mr. Alexander.
Thank you, my lords and my lady. Before I begin, just one matter of housekeeping. In all the documents filed on behalf of the respondent, the application by
Yeah.
however, due to changing circumstances, he has been unable to attend. And
Yes.
I do wish to extend his support.
Thank you.
The respondent's submissions are that the Court of Appeal did not deal in law in upholding the decisions of Justice Budu Singh. The Court of Appeal was correct in finding that the unreasonable delay or delay without a good explanation to extend time was sufficient for the judge below to set aside leave. And 3, that the Court of Appeal was correct in awarding the respondent's cost in light of the agreement between the parties to have costs budgeted at TT $120,000. The pivotal issue which the Honorable Committee has to determine are 1, the correct interpretation and application of Section 11.1 and 11.2 of the Judicial Review Act of Trinidad and Tobago. 2, whether at the leave stage where there is a lack of promptness and delay is in excess of the statutory period of 3 months, is a trial judge obligated to consider prejudice, hardship, and detriment, where there is no good reason to extend the time given by the applicant. 3, whether a trial judge at the leave stage has the discretion to set aside leave inter partes where he has granted leave on the ex parte hearing of the application. 4, whether it was erroneous by the Court of Appeal and the judge below to set aside leave and to uphold the setting aside of leave where there was an agreement by the parties to abide by the decision in a parallel matter. Now, I will deal with the last matter first. It is the respondent's respectful view that the question, that with respect to the last matter, which is at, I will refer your honors to record of appeal, page 231. Where at letter 6, Romans numeral 6. With regard to the issues, it is stated whether it can be right in principle to A, refuse, or B, set aside leave for judicial review in circumstances where parties are agreed that if proceedings are issued, the parties will be bound by the decision in a parallel judicial review proceedings. It is a respondent's respectful view that the appellant ought to be barred from advancing any arguments along this line. This is on account of the fact that this issue which is being raised now was not an issue which was before the Court of Appeal, and therefore the decision of the Court of Appeal did not address this particular issue, and therefore it is not right before this. And we had indicated this, and it is included in the electronic bundle. At page 267, where there is a note at 6. This is an issue raised by the appellant to which the respondent does not agree. It's an issue in the appeal before the to JCPC.
Can I ask you, Mr. Alexander, about the parallel proceedings?
Yes.
Those proceedings have been completed, I think.
Yes, my lord.
And as I understand it, the outcome of those proceedings means that the present appellants are entitled to the documents that they were seeking to recover. Is that right?
Yes, because both proceedings dealt with the issue of freedom of information applications, particularly in regard to the qualifications of persons in a particular position.
Yeah.
In the other matter, that went to the substantive and was determined by Justice Rajnath Lee at that point in time, as she then was. However, it is our respectful view that with respect to this matter, there is a procedural aspect to it, which is the objection to leave being granted on the issue or on the point of delay, being a hurdle that has to be crossed before you can reach the aspect of the substantive matter of the judicial review.
Yeah.
Can I just check, Mr. Alexander? I've understood that it was agreed that the point in issue should be determined by the parallel case. Had that case already reached a determination by the time the judge in this case refused permission?
When he refused the position, the judge had given the order of Rajnath Lee was given on the 7th of April 2011.
7th?
Of April 2011. Decision of the Honorable Justice Budu Singh was on the on the 3rd of October 2011.
3rd of October?
Yes, 2011, which is at page 114 of the electronic one.
So we can take it, I assume, that the judge knew when he refused leave what the outcome of the parallel proceedings had been.
Yes, you could take it that he was aware. However, as the letter that my friends would have passed up to this honorable court at the beginning of these proceedings, the letter dated 29 April 2011.
Yeah.
You see at the third to last sentence, on the second page of the letter. When it is stated, the letter signed by both the attorney and the defendant. The only issue for the determination of this honorable court is the issue of delay and costs.
Yes.
Yeah.
So the parties had agreed that Justice Budu Singh had to give a determination on the question of delay being that threshold point.
And is it a fair reading of that letter that the judge, when he read it, the judge in this case, when he read it, would have assumed, therefore, that the documents had been or were about to be handed over? The undersigned has had a conversation, has indicated he doesn't propose to pursue his submissions made on the merits in this matter. Not be necessary for the claimant in the instant matter to file his written submissions. All that's in issue is delay in costs. Yes, the question is it a fair reading of the letter, as the judge would have read it when he refused permission, that these documents were going to be had been or were going to be handed over?
Well, I think from his understanding in the letter, that the parties had agreed to abide
Yes.
Because as you see, on the previous page, it says on the 7th of the 7th day of April 2007, the matter of the Maharaj against the education facilities company, the Honorable Madam Justice Rajnath Lee ordered that the documents of a similar nature and type to the documents requested were not exempt documents, and the order that they be disclosed, except for personal information of the CEOs.
Can I put the question another way round?
Yes.
If there was the agreement, as we've just seen, that the answer in the other case would dictate the answer in this case, they weren't exempt documents, what was getting in the way of the handing over of the documents?
As I would have indicated, milady, the respondents were taking the procedural point with respect to the application for leave for judicial review.
So was the point being taken that there had to be an order in judicial review before the documents could be handed over? Otherwise, I'm not quite understanding what the judicial review had to do with it. If the documents had been requested, they were not exempt, why weren't they just handed over?
Why would they
Just not handed
handed
over?
Well, I think they wanted to have a determination of the delay point in terms of getting to an understanding of whether or not they were able to cross that threshold in order for the substantive matter to go ahead.
Have the documents been handed over yet?
We have written to the other side indicating our preparedness to handle the document.
I'm sorry, could you say it again?
I said we did write to the other side indicating our preparedness to handle it after the grants of the leave to the Privy Council.
But they haven't actually been given to them.
Yes, they will. But yes, they will. They will.
And I'm wondering, I mean, apart from anything else, just say we were in favour of the appellants in the appeal. Is it still necessary for an order to be made in these proceedings for the documents to be delivered?
No, there's no need for that order, because this honourable court is only being asked now to consider the issue of delay and whether the consideration of hardship, prejudice, or detriment to good administration has to be considered at the leave stage, where it is where the application falls within the parameters of 11.1 of the Judicial Review Act, and rather than 11.2 of the Judicial Review Act.
Yeah,
So in essence, this is an academic point.
Well, that's what I'm wondering. If just say we were with the appellants, what sort of order would we make?
I think if any order were to be made, would be to make a determination as to the correctness of the findings of the court with respect to how the application or the interpretation of Section 11.1 and 11.2 ought to apply.
Yes. Yes, we could allow the appeal. And what would then, and I suppose we would deal with costs. And would anything else need to be done?
No.
I mean, if we allow the...
Because the substantive aspects would have, to use of a better word, been satisfied, seeing that the information was subsequently...
Forgive me, Mr. Alexander. I want to really zero in on what the judge who refused leave thought the position was. If he thought that without a grant of leave, and therefore an extension of time, the applicants would not get their documents, that may say one thing in terms of whether there was a good reason to give leave or to make an extension of time. If he thought that they were going to get their documents anyway, so that all that remained to be dealt with was costs, one might well have thought he wouldn't have thought there was good reason. The trouble is, he didn't say one way or the other. He just said there was no good reason for the delay. But the Court of Appeal thought he obviously meant no good reason for giving leave.
Yes.
And without knowing what his mindset was about whether getting leave was a key to getting the documents, it's very difficult to address that from this remote distance and time. So I'm pressing you, you may not know, but I'm pressing you to try and understand what the judge understood, other than what's said in this letter, about whether, if he didn't give leave, the applicants would get the documents. I must say, reading the letter myself, it rather looks, I think I would have read it as assuming they get the documents anyway. But I don't know. I mean, no doubt the letter was handed over in a hearing and things were said, and the things that were said may put a different cast on what the letter meant.
My lords, I believe that not to impugn what may or may not be his considerations, but I think when you look at the question of what the judge had to determine based upon what was agreed by the parties, his understanding was that I had to determine these two issues. The issue of delay in terms of the procedural aspect, in terms of applying for judicial review, and whether or not if a party has applied outside of the 3-month period, whether or not they are entitled to be granted leave for judicial review if they haven't given a good reason for the extension of time. And then what would be the cost implications for the appellant or the respondent based upon his decision.
But did the judge understand that if leave was refused on grounds of delay, that the applicants would not get the documents? That's what happened, and they haven't had the documents, have they?
Well, they have the documents now.
Yeah,
They have.
28th December 2017.
Say that all I can say, or all I can speak to, is what is on the face of the documents that are before this court. Based upon the letters, based upon the correspondence that were exchanged by the parties, there was intention by the respondent to abide by that decision and to disclose the documents. And even before this matter was brought before the Lords and the respondent attempted to resolve the matter by saying, we will provide you and provided documents to the appellant.
I mean, it's puzzling why, on the one side, there was a desire to proceed with the judicial review after agreement had been reached to be bound by the outcome of the other proceedings, and on the other side, while anyone would bother to seek to challenge leave on grounds of delay.
Let me refer your, my lords, to the record of proceedings.
Yep.
Because it's not just the one letter that was exchanged.
Need to look at the judgment.
To my lords and my lady, to page 48, which is a letter dated the 7th of December from the respondent's attorneys to the claimant's attorneys.
All right, what page do you say we want?
This is page 48.
48?
Yes, 48.
48, thank you.
Letter reads, we received yours of 30th November 2009 and 4th December 2009. We note your refusal to comply with all reasonable requests for full information, which may enable us to avoid litigation or avoid the efficient management of any proceedings. Naturally, we are not keen to become embroiled in litigation over a matter which appears to us to be susceptible to easy and expeditious resolution upon any interpretation of the relevant provisions of the Freedom of Information Act. We have been advised by counsel that Section 30 of the Act governs this matter, consistent with the above and the practice directions, to which we refer in our letter to you, dated 23rd November 2009. We now invite you to consider whether we should not now explore alternative ways of resolving the difference of interpretation. To that end, we are partial to seeking the opinion of leading counsel on whom we may get agree and whose opinion we may agree should bind us. However, by letter dated December 8th, 2009, which is at electronic page 49, the appellant's attorneys respond, "Thank you for your letter of 7th December 2009. This is to advise that my client is unable to agree to your suggestion and has instructed us to file his claim for judicial review. Having already sought the advice of counsel on this matter, we would rather save his resources for the resolution of the substantive issue in court."
The next two pages are perhaps more directly on the point. We have at page 50, your firm, I think, write to draw their attention to the other proceedings.
Yes.
And you write to inquire whether it would be capable of saving costs and judicial time if the proposed proceedings between the present parties should be permitted to abide the outcome of the proceedings in the other proceedings.
Yes.
And then a response to that on page 51 is, provided you give an undertaking that you won't raise the issue of undue delay against us in our proposed judicial review application.
Yes. So you could see that delay was always or already in their contemplation before our response of the 13th of January 2010.
Yeah, and in the next page again, your firm reply saying that that proposal assumes that proceedings will be filed, that the parties will agree that those proceedings should abide the outcome of the other proceedings.
And in light of the above, please be assured that undue delay, if any, as at the date of filing of any proceedings, will be canvassed.
I mean, it rather sounds as though you're going to court in order to resolve the question whether going to court has been unduly delayed.
Where do we find the inter partes submissions when the matter came back before the judge later on?
Well, while the inter partes submissions were filed, I believe there's a letter where the parties had agreed.
Written submissions.
Presumably it's at 99, is it? 99? And at that point, it was just the month before the decision in the substantive proceedings, wasn't it?
Just before the decision,
in the other set of proceedings.
proceeding, yes.
Yeah. Was the agreement still in place to abide by the outcome of the parallel proceedings?
At that time, I believe so, yes.
Yeah. So is it mentioned in the defendant's submissions of March 24th?
It's before the letter, I think. That's just before the letter of the 29th of April, isn't it?
Yeah. Well, never mind if you can't find it readily. It looks as if it sets out the arguments on the substance.
Yes. There's no reference to the agreement.
No.
It rather looks as though you and the appellants had agreed before these proceedings were begun that the outcome of the other proceedings would be followed.
Yes.
As far as I can see, the present proceedings have got no useful purpose.
I think from inception we had accepted that this was an academic point. And that is why we sought to avoid having to engage in further litigation by providing the information.
Well, in response to the appellant's application for leave, which was granted, you then, of course, applied to have the grant of leave set aside on the ground of undue delay, and you succeeded in that. You succeeded in the appeal against that decision, and we're now here before the board.
Now, as we were raising the objection to the issue of the agreement between the parties, as it was not canvassed as a court of appeal, it is, however, in the appellant's submissions where they address the issue of the agreement as part of its submissions as an independent, though not fully as an independent issue by itself, but it's interwoven in its heading of part 3 of its submissions, other issues at page 305 to 306 of the electronic bundle. Lords and my lady with me. So at the bottom of page 305 of the electronic bundle, reference is made to part 3, other issues. Good reasons to extend time independent of hardship, prejudice, and detriment.
I think we all entirely understand that there is an interesting legal question raised in the appeal about the relevance of hardship, prejudice, detriment to good public administration in general terms in dealing with this sort of question under Section 11.
Yes.
So far as I can see at the moment, though, there wasn't actually any live issue of hardship, prejudice, or detriment to good administration in these particular proceedings.
Yes, and to that we agree, because based upon the objection that was raised at the leave stage by the respondents, it was squarely on the basis that the delay was in excess of the 3-month period, which under Section 11.1, it emphasizes, where I'll refer Your Honor, my lords and my lady, to page 352 of the electronic bundle. Where Section 11.1 states, an application for judicial review shall be made promptly and in any event within 3 months from the date when the grounds for the application first arose, unless the court considers that there is a good reason for extending the period within which the application shall be made. It is our submission that that shall provision makes it obligatory on any application or any applicant for leave for judicial review to file that application promptly. And if it is not prompt, it should at least be within a 3-month period. And if it is not within the 3-month period, you have to give the court a good explanation for why time should be extended. It's our submission that that provision is a standalone provision. Because at the end of Section 11, there's no semicolon, there's no inclusion of and to say that Section 11.2 must be considered with 11.1. 11.2 then goes on to say, which is on page 353, the court may refuse to grant leave to apply for judicial review if it considers that there has been undue delay in making the application and that the grant of any relief would cause substantial hardship to or substantial prejudice the rights of any person or would be detrimental to good administration. It is our respectful view that at 11.2 is when the court or the judge's discretion is brought in to then consider whether there is hardship, prejudice, or detriment to good administration. However, that is only in certain circumstances. Those circumstances are where the application, though not prompt, is within the 3-month statutory period. And in circumstances where the application is not prompt, is outside of the 3-month statutory limitation period, but you have given the court or the trial judge a good explanation for why that time should be extended. Excuse me. So it is the respondent's submission that in respect to 11.1, which is then qualified by the provisions of the CPR, page 361 of the electronic manual, where at 56.5.1, the judge may refuse leave or to grant relief in any case in which it considers that there has been unreasonable delay before making the application. 2, where the application is for leave to make a claim for an order of certiorari. The general rule is that the application must be made within 3 months of the proceedings to which it relates. Now, it is our respectful view that the provisions of 11.1 and 56.5.2 make it that the application for judicial review is a time-sensitive application, meaning that, 1, it must be made promptly. So as soon as the decision is given to which you wish the courts to review, you bring it before the courts. If it is that it is not brought immediately or as soon as possible, you have to do it within 3 months. And if you fail to do it within 3 months, you give the courts a reasonable explanation for why an extension of time should be granted.
Why are we looking at 5652, which is about certiorari?
Well, 5652 affirms that 3 months limitation period.
Isn't it a particular,
But that's for a particular
Variety.
form of relief under public
Yeah.
law, yes.
which we're not talking about
Which
here?
we're not talking about in this circumstance.
No.
But in terms of section 5615, where the rules make reference to unreasonable delay, we interpret that unreasonable delay to be a delay where you have given no reasonable explanation for the delay, which in Abzal Mohammed, Justice Kanglu does affirm that a good or explanations for the delay, it forms part of the considerations for the extension of time, or at least is one of the considerations for the extension of time.
I don't get the impression there's any dispute between you that the explanation for the delay is part of the factors that have to be considered.
So that's,
But the dispute is whether at that stage the judge can have regard to whether or not there's prejudice. You
Exactly.
say not,
We
they
say no.
say yes.
exactly.
And that's the dispute between you.
That's the dispute, yes.
Yeah.
That is literally what the dispute is.
So if that's the dispute between you, what do we make of section 11, subsection 3, leaving out of it about the time when they became aware of the making of the decision, and just reading, informing an opinion for the purposes of this section, the court may have regard to such other matters as it considers relevant. So that's 3. It's talking about forming an opinion for the purpose of this section.
Yes.
So it's not only tied to 11.2.
2.
It can be in 11.1 as
It
well.
can be 11.1 as well. But that is at large. The judge exercising his discretion listens to what reasons are provided by the appellant, who acknowledges that they need to apply for an extension of time, and looking at those reasons determines whether or not he, in his opinion, thinks those are reasonable explanations for why time should be extended.
Well, do we have, it's a good reason for extending the period, which he's looking for. Does he have to, on your argument, exclude from that? He can look at everything, but he mustn't look at what's in 2. Is that the logic?
All logic, or our understanding, is that where 11.2 applies, is that you are considering those specific factors if you are considering whether or not to refuse leave on the basis that this application has been made within the 3-month period or good reasons have been given. So those are additional considerations other than the good reasons or good explanation for the extension of time. Now, looking at the specific facts of this particular case, my lady and my lords, when you look at the appellant's application itself, which is at of the record of proceedings. If you turn to page 12 at G, you see the reasons for the. Now I will juxtapose this against the Fishermen's and Friends and the EMA against PP Trinidad and Tobago case. Now, in their application for leave, the respondents takes the position that, one, there is no delay, and in the making of the application, and rather relies on the fact, or explains that by saying that they were utilizing alternative remedies provided for under the Freedom of Information Act. He then goes on to say that even if there was delay, it was justified, as judicial review should be invoked as a last resort, and hence time should be extended. This is all that is provided to the court. However, I wish to refer Lords and Milady to page 618 of the electronic bundle.
Say 16.
618. At 618, you'll see the High Court's decision of Barrow J, as he then was, in Fishermen and Friends, and against the Environmental Management Authority and BP Trinidad and Tobago. Now, in that case, Fishermen and Friends acknowledged that there was delay. And in their application, they go further to outline the reasons or their explanation for why they believe an extension of time should be granted. Lords and Milady to page 629 of the electronic one. At 629, the judge outlines what were the reasons given by the applicants for an extension of time. So he itemizes, one, the respondent's failure to disclose that it had been granted a certificate of environmental clearance to PBTT. The appellant did not become aware of the application until mid-March 2002, and that only after 3 visits to the respondent's office that he became aware of it. 2, those visits were made after he became suspicious about the contents of a letter dated 14 February 2002 from the respondent, in which it responded to certain concerns raised by the appellant. 3, the respondent had not established the National Registry of Certificate of Environmental Clearance, or when told by the officials of the respondent that the Certificate of Environmental Clearance was granted, he applied for official copy, which was obtained in mid-March, and I know that Mr. Abood gives no dates of the application for such a copy, nor does he name the official. And 5, after becoming aware of the decision, it was necessary to inform its members, receive legal advice, accumulate information for onward transmission to its lawyers, and consult with experts in assisting in the preparation of the application. And then at 6, in any event, the subject matter of the application raises issues of public interest, and about the serious threat of human life and the environment, and public interest issues come down in favor of granting the application. So you see, in that circumstance, where in your application for leave for judicial review, where you are aware that delay is an issue, you outline fully for the consideration of the courts the reasons why an extension of time should be granted. Now, in that case, Bureau disagreed with the applicant, finding that those reasons were not good reasons to extend time, particularly reason number 5. Where he held, and I refer Laws of Milady to 631 of the electronic fund. Where he says, the lapse of almost 2 months from mid-March to the filing of the application is far more difficult to justify. I am mindful of Mr. Maharaj's submission that the preparation of the matter for court was a burdensome task, which, given the sheer volume of the documents presented to me. I am also minded of the dictum of Lord Stein in R. Burkett and Hammersmith and Fulham London Borough Council at page 50 to the same effect. No doubt, the documents presented in this case was as much a task to prepare as it was for me to read it. But in the context of the facts of this case, the time taken to proceed to court was simply too long. The decision to grant the Certificate of Environmental Clearance brought the right of BPTT into the equation and required that action be filed with urgency. While legal action was being prepared, the project was proceeding apace. In my judgment, no good reason has been put forward for the granting of an extension of time. Now, in the present case, looking back at G in their application, no reasons at all are given by the appellant with respect to why time should be extended. Further to which, no issues of prejudice, hardship, or anything to the detriment of good administration are raised or outlined in their application for the court's consideration. Pivotal to note my initial point in terms of that applications under 11.1 are being time sensitive and they should be made promptly. And this is on the basis that the overriding objective requires that matters, particularly of a public law nature, be brought to the courts expeditiously so that they can be dealt with and so that they cannot be allowed to congest the legal system. However,
can I just ask you, does it follow, just having read that passage out, it referred to the fact that the project was proceeding apace.
Yes.
He refers to that in the context of
Yeah.
good reason. Does it follow from your argument that you would not be able to say to the court, knowing it was faced with an application to extend time, and by the way, we've acted in the following ways which would make it thoroughly prejudicial if time was extended?
in terms of the respondent's
Yeah.
position, I think the respondents in its position could have expressed issues with regard to how the application were to be granted. It could have been detrimental to them. However, this is a question of, again, when you look at it, is merely the provision of information, the provision of a resume, a provision of the qualifications of a member of the respondent or the head of the respondent. And based upon the application itself, the position has been taken that there's no delay. So therefore, I have nothing to explain. Basically, this is the position taken by the appellants. There's no delay. I don't need to give reasons, and you should extend my time. But at the end of the day, the 3-month period that you are required within which to file your application has passed. And then you indicate on the 8th of December, I am going ahead and file my application for judicial review. However, you don't file anything. You are saying that you're relying on the alternative remedies that are available under the Freedom of Information Act, which is you go to the Ombudsman for determination. The Ombudsman provides a determination on the 19th of November, which is the same anniversary date for the filing of your application for judicial review within 3 months. You get a decision not in your favor, but you do not file anything. December 8th, you indicate that you are going to file, you do not file anything. 2 months then, well, a month goes by until the 20th of January, when you then file your application, then indicating that, or requesting of the appellant, that, or the respondent, that they do not canvass the point of delay. You are aware with certainty by the 13th of January, 2009, that, or 2010, sorry, that delay is going to be canvassed. However, in your application, you do not provide any information or any reasons why time should be extended. And we submit to this court that failing to provide reasons why time should be extended, you can't satisfy that initial threshold of 11.1, meaning you are out of time, you are not within the 3 months, and you do not give a good reason, then there's nothing else for the court to consider, because at that point in time, leave cannot be granted. Now, in the same Fishermen's and Friends first instance decision, what is noteworthy is the dicta of Justice Barrow, as he then was, where my lord and my lady will find that the Honorable Judge analyzed how Section 11 of the Judicial Review Act ought to be applied. I refer my lords and my lady to page 627 to 628 of the electronic one. Affirming the ex parte Jackson and ex parte Caswell decisions, Justice Barrow held that the decisions in these cases, though not binding, are highly persuasive. I agree with them and will summarize the law they establish in the following terms. 1, the words "an application for judicial review" refer to the ex parte application for leave to apply, not to the substantive application. 2, it is an essential requirement that an application should be made promptly, and whenever there is a failure to act promptly or within 3 months, there is undue delay. 3, the fact that an application has been made within 3 months does not necessarily mean that it has been made promptly. 4, if there is good reason shown for extending time, the court may grant an extension. But even if the court considers that there is good reason, it may still refuse leave if the granting of the relief sought would be likely to cause hardship, prejudice, or be detrimental to good administration. In the present case, my lords and my lady, the appellant contends that the delay that needs to be explained is of the 7th December 2009, which is highlighted at page 259 of the electronic bundle. Where in the table of agreed chronology, they refer to the letter to the appellant's representative on behalf of NEC proposing that the parties resolve the matter by joint instruction to leading counsel to opine on the application of Section 2 Act. However, the respondent submits that time began to run from the 18th of August 2009 when the original decision was given. And the latest the application for leave ought to have been made or filed was the 19th of November, the expiration of 3 months, which is the expiration of this 3-month statutory period. Nonetheless, on that day, the Ombudsman, being the alternative relief provided under the Freedom of Information Act, gave his decision, and therefore promptness required that they file immediately thereafter. However, like in Fisherman and Friends, the appellant failed to do so for an additional 2 months, without giving any good explanation for why he sat on his hands and why time should be extended, particularly when the 13th of January 2010, he knew with certainty that the issue of delay was going to be canvassed. Now, my lords and my lady, the appellants in their submissions are relying on Afzal Mohammed and the Police Service Commission to establish the requirement by the judge at the leave stage and to establish that the judge at the leave stage has to consider hardship, detriment, and prejudice. And also relying on Afzal Mohammed and the Police Service Commission to establish the error of the majority in the Court of Appeal. We refer, Your Honors, to page 468 of the electronic bundle. Now, the decision of Kangaloo J was delivered on the 31st of March 2010. However, the Privy Council in Fisherman and Friends delivered its decision on the 25th of July 2005. So at that point in time, the Privy Council's decision in Fisherman and Friends was good law in explaining the application of Section 11.1 and 11.2 of the Act. Because in Fisherman and Friends, the Privy Council affirmed the interpretation of Barrow J in the court below. Lord Walker held at page 646 of the electronic bundle, that fishermen and friends of the sea had to make out a case for an extension of time under Section 11(1) of the Judicial Review Act. The judge correctly analyzed the effect of the authorities on the analogous provisions applicable in England, including the Queen against the Dairy Produce Quota Tribunals for England and Wales ex parte Caswell. The judge asked himself whether there was a good reason for extending the time for the application. He listed some salient points in favor of fishermen and friends. Nevertheless, the judge, in effect, gave fishermen and friends the benefit of the doubt for delay down to mid-March 2002. But he considered that the lapse of about 2 months from mid-March to the filing of the application on the 20th of May 2002 was far more difficult to justify. He concluded that fishermen and friends had not shown good reason for an extension of time under Section 11(1). He then goes on at page 650 of the electronic bundle. At the very end, paragraph 32, state that in these circumstances, the judge's exercise of his discretion was not flawed. There is no reason to interfere with his decision not to grant an extension of time, and the appeal must be dismissed. However, in Afzal Mohammed, Justice of Appeal Kangaloo failed to consider the findings of the Privy Council, which affirmed the dicta of Beroji. It is for this reason we contend that Afzal Mohammed is improprium. Nonetheless, while we challenge the correctness of the application of Section 11(1) and 11(2) in Afzal, we wish to draw the Lord and Milady's attention to the finding of Kangaloo at page 476 of the electronic bundle. At page 476, paragraph 23, Kangaloo states, to the extent, therefore, that the judge below focused on delay, which he erroneously calculated at 5.5 months, when it should have been 20 days, I am of the view that that he erred in principle. He goes on to say that I am therefore of the view that the discretion whether to grant leave should be reviewed and looked at afresh. In this case, the delay is short and the appellant's behavior reasonable in attempting to get the commission to review the decision before going to court to challenge it. Where the conduct of the appellant fell short was allowing the 3 months imposed by the legislation where certiorari is sought to run out. It is not self-evident on the appellant's application, nor has it been shown by the Commission that the grant of leave would be likely to prejudice others or be detrimental to good administration. The only other hurdle the appellant has to jump in this case is whether he can show that that there is good reason for the court to extend the period of time for making the application. The respondent submits that in Abzal Mohammed, if the court is finding that the delay is for 20 days, then the court is finding that Abzal Mohammed falls within the 11.2 category rather than the 11.1 category, wherein the questions of prejudice, detriment, and hardship are to be considered. Nonetheless, the fact that the judge acknowledges that the appellant allowed the 3 months to run out means that if he considers the delay of only 20 days, that means you are not considering the question of promptness, which is paramount as established by 11.1. And in taking away or not considering the question of promptness, he is plainly wrong in making that determination. Now, as we have established, or we have submitted to this honorable board, is that the appellant in his application has given no good explanation why his time should be extended, and therefore he cannot fall within the 11.2 category for the questions of prejudice and hardship to arise. However, the appellant in his submissions, goes further to bring in this concept of relevant delay, where they say that relevant delay is being delay past the 3-month statutory period or delay within the 3-month period. The appellant purports that an extension of time is needed in both circumstances, which in our respectful view is incorrect, because it is only in the 11.1 category where you are outside of the 3-month period that you have to seek an extension of time. In the 11.2 category, if your application do not prompt, falls within the 3-month statutory period, then the court has to then consider, in order to whether or not it's going to exercise its discretion to refuse leave, whether or not there is prejudice, hardship, or detriment. And this, it is our view, brings us to what we perceive to be the either-or scenario, where it is either there's delay and you give a good reason, or you have no good reason and you are out, or there is delay and you have given a good reason, but you must now satisfy whether there is prejudice, hardship, or detriment to good administration. We wish to refer your honors, lords and my lady, to page 1147 of the electronic bundle. And specifically 1159. Where it is stated at paragraph 2 or 26.1 with regard to the approach to delay, and this is from Queen's Counsel, where it states that judicial review claims are required to be commenced promptly. Stop.
Sorry, you're reading from paragraph 21?
26.1. This is at page 1159.
Thank you. Yes, thank you.
So judicial review claims are required to be commenced promptly. At the permission stage, the court can refuse permission for lack of promptness if either, one, there is no good reason for extending time, or, not and, but or, two, the combined effect of the delay and the likely hardship, prejudice, or detriment from the remedy sought justifies dismissal of the case. At the substantive hearing, a remedy may be refused or delayed on grounds 2 alone. However, in the present circumstance, we never reached the substantive stage. We remained at the leave stage. And therefore, it was a question of whether there was a good explanation or good reason to extend time, or the questions of prejudice. And failing to satisfy the first, there was no reason to consider the latter. Now, on the issue of the judge's right to set aside leave, we wish to refer my lords and my lady to the case of Sharma against Brown Antwine, which is at page 1099 of the electronic bundle. Now, in the present case, leave was granted ex parte on the 21st of January 2010. Yes, on the 20th of January 2010. However, we submit that the Honorable Justice Budu Singh was correct in having the power to set aside that leave when the application then became inter partes. Because
There's no issue between you, I think, about this, is there? I don't think there's any issue between you and Mr. Fordham on the entitlement of a judge to set aside.
It is one of the issues that, and I don't recall the appellant conceding the question of the right of the judge to set aside.
Yes, he had the right to do it, he just shouldn't have done it.
Yes, I mean, there's no dispute that he's entitled to do it in some circumstances. The issue is in what circumstances,
Yes.
and in particular those of the present case.
And we are saying that in this circumstance, he was entitled to do so because there were circumstances. This was a circumstance in which he ought not to have granted leave to begin with. because, again, going back to the application of 11.1 of, or the standalone application of 11.1 of the Judicial Review Act, wherein the fact that the appellant being outside of the 3-month limitation period was required to give a good reason for the time to be extended. There's no evidence before the court, there's no evidence in his application of what are the good reasons for extending time. So the judge had very little to consider. The judge was correct in finding that there was no good reason for the delay because that was the only explanation given. And in such a circumstance, where you haven't given a good reason for time to be extended, and you are outside of the 3-month period, leave ought not to have been granted. So in the circumstances when the application became inter partes, the judge was within his rights to then set aside the leave. And this is affirmed in the Sharma Brown Antwine decision of the Privy Council, where at 11:08 of the electronic bundle, it is stated, where leave to move for judicial review has been granted, the court's power to set aside the grant of leave will be exercised very sparingly. And reference is made to the Queen against Secretary of State for the House of the Home Department ex parte Chinoy. It then goes further to say, but it will do so if satisfied in inter partes arguments that the leave is one that plainly should not have been granted. So that is at paragraphs C and D of the decision in Sharma and Brown Antwine at page 11. In closing, it's the respondent's submission that one, the appellant's application for leave for judicial review is one that falls within the 11.1 category, wherein it is outside of the 3-month period, it is not prompt, and he has given no reason why time should be extended. And in such a circumstance, leave ought not to have been granted. Further to which, it is a paramount consideration in these public law applications that they be brought promptly. Because if the courts were to completely disregard promptness and allow applications to be brought in after that limitation period, which is this line that is drawn in the sand, in our opinion, then the court will then be inundated with applications outside of that statutory period, which will only go against the objective of ensuring that there is expediency in the determination of these matters and that there is certainty with respect to the respondents. Further, we submit that the Court of Appeal, majority in Justice of Appeal Barrow and Justice of Appeal Smith, were correct in their application and interpretation of Section 11.1 and 11.2 of the Judicial Review Act. And that Justice Budu Singh was correct when he set aside the leave at the inter partes stage of the hearing of the leave application. If I can't assist this court any further, that is the submission for the respondents.
Any questions? Any questions? Well, thank you very much, Mr. Alexander.
Much obliged, my lords.
Do you wish to reply, Mr. Ford?
Yes, please. Was it all a waste of time? No, it wasn't a waste of time. The document was not handed over after April 2011 when the parallel proceedings had succeeded, even though the parallel proceedings dealt not only with the exemption and the statutory right to the information, but it also dealt with the delay point. Because as you're just being handed, and I told you this before, there was an extension of time in the parallel proceedings. The document was not handed over as at the date of the inter partes hearing in October 2011, and it wasn't handed over at the time of the Court of Appeal hearing or after the Court of Appeal hearing. The position was, as has been confirmed to you, that the respondent took the position that we had to break through a gateway of a delay objection for us to get that document. And they were raising that delay objection, and you've seen it in the papers at page 52 in the bundle, where in the letter of the 13th of January at page 52, we're told, and this is the first time we're told that delay is going to be raised, the middle paragraph indicates that it will be the delay point raised in the parallel proceedings. All the issues, including undue delay, which are capable of arising in both proceedings, may be conclusively resolved in the other one. In the other one, the delay point didn't hold, and judicial review had been granted in April. But it was the next paragraph. In light of the above, please be assured that undue delay, if any, we file a week later, if any, as at the date of filing of any proceedings, will be canvassed as part of the case of our client. And so it was, because they resisted judicial review, see page 98, which is the entry of an appearance. Do you intend to defend the claim? Paragraph 6, yes, and that remained their position. They applied to set aside the leave on grounds of delay, see page 91. They put in submissions on the merits, on the exemption, and it was those that were withdrawn. So if we got through the gateway, we were going to win. And you'll see at page 100, at paragraph 4, we've already addressed you on delay, so here's our submissions on the merits. Page 100, paragraph 4. And when that letter goes in, the letter that goes in tells the judge, we're not proposing to pursue the submissions on the merits. In those circumstances, you just have to decide delay and costs. Not costs. If you think about it, it would just have been costs if this were academic. Delay and costs. Why? Because as he's confirmed today, and he's right, their position was, you can't touch us if you're out of time. We don't have to give you it. No court would make an order, and you won't have it. And that's what's rather interesting. Justice of Appeal Smith, at the beginning of his judgment in the Court of Appeal, refers to the case as being academic in a sense, but the description that he gives is he says the substantive issue is academic. At page 196, paragraph 2, the substantive case for judicial review became academic. But we never got to the substantive. They said they hadn't got a leg to stand on if we could get through the leave door. And at that point, they would have caved. And we would have got our document. And we would have got our document 7 years before we did get our document.
Right. I think you're helping me to understand what's gone on here. So if in the judges, I was puzzled by paragraph 17 of the judge's judgment. It's on page 114. This is having narrated in the previous paragraph that he found that there was unreasonable delay and set aside the order giving leave. Then his final paragraph is, I was informed the other matter was resolved in the claimant's favour and the parties will abide by it. Now, one might have thought that that in itself was ample reason for finding there was no good reason for allowing this application for judicial review to proceed. It's moot. But it sounds as though what he's meaning is, well, he's mentioning this at the end because it's only after he's found that there was unreasonable delay and has therefore set aside the order giving, well, I wonder. I know that still doesn't make sense because on your account of the approach of the respondents, having won before the judge and had the order set aside, you would have thought there would be no question of
What he's saying is,
producing the documents.
he certainly doesn't say they're abiding by it and they're going to be producing the documents. They would have done that already if that had been the position. And as you've heard, their position was straightforward, which is that we are resisting this claim, but we've only got one point on which we can resist it, and it's delay. So please find that in our favour. And he did. What he says is, the other matter was resolved, and the parties will abide by it. Well, you've seen what he was told about that. Given that position, and also that I had not heard any submissions on the merits of the application, I made no order as to costs. He knows there's a merits. He also knows they haven't got any merits because they've accepted it. But he's focusing simply on the question of delay because that's the basis on which they are resisting the claim. Sorry. And I'm told paragraph 1 of his judgment as well that that was adjourned because a similar matter was pending.
I'm sure I don't need to tell you, but clearly entitlement to the documents didn't depend on getting an order in judicial review proceedings. Either they're entitled under the statute or they're not. And the other proceedings had established that they were entitled.
Yes, but if the delay point means anything at all, it enables a public authority to say, you have no entitlement to a remedy, and you have no entitlement to it. You're entitled to the documents, congratulations. You can have a declaration to say you're entitled to the documents. We're not giving them to you. And we're not giving them to you because you wouldn't be able to get an order, and you wouldn't be able to get an order because you're too late. Now, it's very unattractive because it's very unattractive, but that was their position, and that's why we didn't get it. So, correct, this is our point. And by the way, it's said against us that we didn't take the point in the Court of Appeal that the parties had agreed to be bound. But we did take the point in the Court of Appeal that the parties had...
What does the judge mean in paragraph 17 by saying, and the parties will abide by it?
The only alternative is that he thought we were going to get that document.
Yes.
If he thought we were going to get that document, he misunderstood why he was being asked to decide a delay and not just costs. That's all it would have been.
It would have been relevant to costs because
absolutely
at the
would have
time
been
when the
relevant to
proceedings
costs.
were issued, the concession to abide by the other case hadn't been made, but there was still a delay that would be relevant to costs.
It would have been, and that's what would have happened. And just to test that out, let's suppose we'd been given it because of the other case. And they had said, but we're not paying your costs because of the delay. We'd have said, right, we'll go to the judge just on the question of costs. And we would have said to the judge, we've now got the document, but that's not the point. You have to focus on whether there was a good reason to extend time in our judicial review in all the circumstances, including the absence of prejudice. And it wouldn't have been an answer for the judge to say, well, you've got the document. You would have had to have posited that in order to answer that. So I don't, with respect, accept the contrary. The point was raised in the Court of Appeal. It's pages 136, paragraph 5D. And 136, paragraph 5D. And 148, paragraph 22. We made the point, by reference to the strength of the claim, that it's been conceded on the merits. This is unlawful. So it wasn't a waste of time. Indeed, we needed it. Were our written grounds deficient because they didn't invoke the absence of prejudice? We've seen them at page 12. Those were the grounds that got leave. Page 12. The written application for an extension of time. We got leave after that. There was then the inter partes hearing, at which there was the challenge. And as I've told you, that was oral submissions, and the absence of prejudice was relied on before the judge at the inter partes hearing. So the parallel with Justice Barrow and Fisherman Friends of the Sea, he says these are the points that have been relied on. He'd had a 4-day hearing. This judge had had a hearing, and this point was relied on. Is it important for you to look at it? Well, respectfully, we submit that it is. Leave was granted by the Court of Appeal on the ground that the appeal raised issues of great general or public importance, the local courts wanting guidance in the light of conflicting decisions. You've not been invited by either party not to. Of course it's a matter for the board ultimately, but I would respectfully ask the court to decide the issue.
Well, Mr. Fordham, if we were otherwise with you, and I'm purely hypothetically...
Yes, remedy.
Well, yes, because as I understand it, you either now really have got the documents or you really have been promised them.
Can I deal with that? The remedy is allow the appeal with costs. If you go to the end of Mr. Justice of Appeal Jamadar's dissent, page 193 to 194, he was going to remit it. Paragraph 68. Because it was now conceded, there is no hardship, judge didn't think about it, needs due consideration. Of course, we haven't got the document. End of paragraph 68, 193 to 194. I'm not inviting that. There's no further order needed in this case.
So you don't need it to be remitted?
No, we don't.
You don't need any kind of
to be remitted.
Any kind of judicial review order?
We don't. Please allow the appeal. Back to the substance then. Sections 11.1 and 2. My learned friend submitted that section 11.1 stands alone. He's wrong. Even for the question of relevant delay, it doesn't stand alone. Promptness, we know, is the same as undue delay in 11.2. It was put to him by my lady, Lady Black. Well, what about 11.3? And he then conceded that a respondent could raise hardship, prejudice and detriment under good reason to extend time. There is a follow-up question. What if you did? Could the judge ignore you and decide not to consider it? Of course not, for two reasons. One, because obviously you have to deal with a point that's been raised that is relevant, and it is relevant. But secondly, it's Alice in Wonderland, because you're entitled to raise it under 11.2 anyway. So you can't get out of that courtroom without a judge addressing your question with due consideration. Wrong. Read them together, even if it is only overlap, but we say it's not. It's fusion. He also submitted that hardship, prejudice and detriment only arise where the claim is not prompt or you're outside 3 months and there's a good reason to extend time. But it's really the same answer precisely, teased out by the question that he fielded. He then submitted that section 11.1 is qualified by CPR 56.5, and you heard him read out 56.5, 56.51, 56.52, stop. But why? 56.53 is a rule. He hasn't submitted that it's inconsistent with the statute. It's not inconsistent with the statute. And yes, you read them together, but 56.5.3 is crystal clear in reinforcing what would be the position in principle anyway. You're left with these key points we respectfully submit. Have you been given any justification for the lack of even-handedness that means that respondents and third parties can always invoke the presence of prejudice, but applicants can't invoke its absence? They can always invoke it in a delay case before leave is granted, but there are cases where we can't invoke it in a delay case before leave is refused. Question 2, has he given you an answer to that rule? Sub-rule 3. And the answer is no. And I showed you the inconsistency when you look at Justice Barrow's threefold division, his second question, and then his stripping out in his final paragraph of of hardship, prejudice and detriment with the rule. It simply doesn't work. You can't put them side by side. Is there some ex parte problem why a case like Greenpeace should fail because a judge on the papers say, well, I just don't know enough, so I'll refuse leave, because that's the logic. And there is no reason, none has been put forward. And I do just need to add one practical point that I didn't make earlier. Under our rules, there is a duty under the practice claim practice protocol to notify the Solicitor General. And you'll therefore see on page 35, when we write our letter before claim, it's copied to the Solicitor General. It's required to be. And that's because the Solicitor General has the overall governmental perspective to raise at the very beginning anything that a judge needs to know. And moreover, under the practice direction, a respondent's letter of response is supposed to go to any interested party. So if there is a developer, for example, who's in the frame, they will be notified. So that's just part of the practical picture for the court respectfully to be aware. I'm not going to say anything about textbooks other than that if you looked at the case law in a textbook, you'd find at page 1168 Greenpeace, and Greenpeace has the three headings. It's paragraph 26.3.2. You'd find at page 1161 all the AN Criminal Injuries Compensation Board case law about why hardship, prejudice and detriment is the issue at the substantive stage. I've already addressed you about all of this, but just for somebody's comfort anyway, 1161, 26.1.7, and I have already accepted, as did the dissenting Justice of Appeal Jamadar at his paragraph 29, that you can have a case where leave is refused for delay independently of prejudice and detriment, but you just have to give due consideration to them. And if you'll forgive me, I will just close by reminding you of something that I didn't have time to show you, though I did refer you to it when I was on my feet, because it is the House of Lords and it is the delay rules, and it's Burkett at volume 2, tab 19. I can't, of course, ask you to turn it up unless you wish to do so, but in Burkett, where Lord Steyn is addressing a justice issue, it's about planning permission and whether someone should be shut out because really you should have challenged the resolution for planning permission and rather than waited and challenged the later planning permission. Lord Steyn at page 880, when discussing that issue, having, by the way, just discussed the Greenpeace case, makes two policy points that he says are policy considerations to be considered. And I respectfully submit that they are relevant to the debate we've had all day. The first is at his paragraph 45. The context is a rule of court which by operation of a time limit may deprive a citizen of the right to challenge an undoubted abuse of power. And that's our case. We've got an unlawful decision, and we know we have, but by operation of a time limit, we're being deprived of that. So it is an access to justice issue. And the second point he made is, secondly, paragraph 46. Legal policy favours simplicity and certainty rather than complexity and uncertainty. And when you're considering the way these issues are dealt with by a leave judge, bearing in mind you still haven't been shown a single example of extend the time but refuse the leave, which is the logic of it. That question of what would you do as a leave judge? Well, you've got relevant delay. Would you just ask a composite question where you would take account of all relevant considerations? If the public interest is raised, you'll give it due consideration. And if the absence of prejudice is raised, you'll give it due consideration. And hardship and prejudice and detriment raised by the respondent or third party, will give it due consideration. What is the straightforward and just application of these rules? And we respectfully submit to the board that the appellant's solutions, whichever one you were to adopt if attracted to them, would fit the bill. Those are our submissions in reply.
Thank you. Well, we shall endeavour to do our best to follow Lord Staines's admonitions, and we'll take time to consider our judgment, and you will be notified in the usual way.